On April 29, 2026, the federal agency responsible for regulating every gun store, every gun manufacturer, and every firearm transfer in the United States signed off on 34 separate regulatory changes in a single day. Not one new rule for multiple law firms and industry trackers are calling it the most significant firearms regulatory reform effort in the history of the ATF. So, what actually changed? Who does it help? Who does it hurt? And why did this happen now in the same year that several states are moving in the exact opposite direction, passing some of the strictest new gun laws in a generation? If federal rules are loosening at the same moment state rules are tightening, what does that actually mean for you? Whether you own a firearm, sell one, or have never touched one in your life, let's break down exactly what happened. Because the honest answer is more complicated and more interesting than either side of this debate wants to admit. Now, let's get into what actually happened on April 29th. To understand why this particular announcement is being called historic, you first need to understand who's making it. The Bureau of Alcohol, Tobacco, Firearms, and Explosives, known simply as the ATF, is the federal agency responsible for enforcing the nation's firearms laws. Every licensed gun dealer in the country operates under rules the ATF writes and enforces. Every manufacturer, every importer, every lector of certain regulated weapons answers to this agency in one way or another. When the ATF changes its regulations, it doesn't just affect a handful of specialists. It touches the entire firearms industry from the factory floor to the counter of your local gun shop. On that April afternoon, newly confirmed ATF Director Robert Sakata stood at a news conference alongside representatives from the National Rifle Association, the National Shooting Sports Foundation, and other gun rights and industry groups and described the package of 34 proposals as the most significant modernization of ATF regulations in the agency's history. That's an extraordinary claim for any government agency to make about itself. So, is it true? Let's actually look at what's in the package rather than just taking anyone's word for it, because the details matter here far more than the headline. The centerpiece of the announcement builds on a policy shift that had actually begun a few weeks earlier in March of 26, when the ATF terminated something called the Enhanced Regulatory Enforcement Policy. This was a Biden-era directive that instructed ATF field divisions to pursue license revocation against federally licensed gun dealers for a defined set of what the policy called willful violations. Things like paperwork errors on the required transaction form known as Form 4473 or discrepancies in a dealer's mandatory record-keeping book. The replacement policy, called the Administrative Action Policy, takes a fundamentally different approach. It emphasizes tracking where firearms actually end up and public safety outcomes while explicitly deprioritizing what the agency now calls immaterial paperwork errors. In plain terms, a dealer who misspells a customer's street address on a form is no longer treated with the same enforcement posture as a dealer who knowingly sells a firearm to someone legally prohibited from owning one. Ask yourself this. Is that a reasonable recalibration of enforcement priorities toward things that actually matter for public safety? Or is it opening a door that lets genuinely careless or bad actors slip through under a friendlier label? That's a real question, and reasonable people land on different sides of it, which is exactly why we're going to look at both perspectives before this is over. The National Shooting Sports Foundation and multiple dealer advocacy groups had lobbied hard against the old enforcement policy, arguing it was being used to shut down otherwise law-abiding businesses over trivial mistakes that had nothing to do with actual public safety. From the industry's perspective, the shift away from that policy is a long overdue correction, one that lets legitimate dealers who make an honest clerical mistake keep their license instead of losing their livelihood over a typo. Now, let's get into the substance of the 34 proposals themselves, because the ATF organized them into 5 distinct categories and each one tells a slightly different story about what's actually changing. The first category is called repeal, and it targets regulatory language the agency says either exceeded its own statutory authority, failed to survive judicial review, or simply didn't produce the outcomes it was originally designed to achieve. The most notable item here is the formal move to rescind the 2023 rule that had reclassified certain pistols equipped with stabilizing braces as short-barreled rifles, a classification that would have required those firearms to be registered under the National Firearms Act. That rule had already been tied up in litigation for years, and this proposal would make its rollback official at the regulatory level. The second category, modernize, focuses on updating decades-old requirements to reflect how the industry actually operates today. This includes a comprehensive revision of Form 4473 itself, Described by multiple industry trackers as the biggest proposed change to that form's workflow in years, covering how it's completed, stored, and processed. It also includes proposals around electronic record keeping, essentially building a permanent regulatory framework around the shift away from paper-bound books that most of the industry has already been making informally for years. The third category, reduce burden, is where some of the more eyebrow-raising individual changes lie. One proposal would eliminate the need for advance notice or approval before someone travels across state lines for a short period up to a year with a lawfully registered NFA firearm, meaning a person traveling with a registered short-barreled rifle would no longer need to file a specific form and wait approval before that trip, as long as the travel wraps up within 12 months. Another proposal would allow married couples to jointly register and possess NFA firearms without setting up a legal trust and would treat transfers between spouses under that joint registration as something other than a formal separately taxed NFA transfer. A third would eliminate the requirement to forward copies of NFA applications to local chief law enforcement officers for their information, a step that had long been criticized by gun rights advocates as redundant since local law enforcement notification doesn't actually grant or deny approval. It's simply informational. The fourth category, clarify, addresses areas of firearms law that have been genuinely unsettled for years, sometimes creating real confusion for ordinary gun owners simply trying to follow the rules. The most consequential proposal here would clarify federal preemption protections for gun owners traveling through states with stricter firearms laws than their home state, treating routine and reasonably necessary activities during that travel, an overnight hotel stay, a stop for vehicle maintenance, refueling, a medical emergency, as legitimately part of protected transport under existing federal travel protections. If you've ever wondered what happens to a lawful gun owner from one state who simply needs to stop for gas while driving through a state with much stricter laws, this is the ATF trying to draw a clearer line around exactly that scenario. The fifth and final category, align, focuses on bringing import, export, and transfer rules in line with current statutory authority and existing business practices, including new procedures for firearms activity within foreign trade zones and customs bonded warehouses, and clarified rules for importing certain dual-use firearm components where a legitimate sporting configuration exists at the point of entry. Layer on top of all of this something that had already taken effect a few months earlier, and the picture starts to come into full focus. As of January 1st, 2026, the 200 federal tax stamp, the fee that had been required for decades on every transfer or manufacturing application involving items regulated under the National Firearms Act, suppressors, short-barreled rifles, short-barreled shotguns, and a category called any other weapons, was eliminated entirely for those categories. That change came out of a broader piece of federal legislation passed in 2025. Machine guns and destructive devices notably were not included in that tax elimination and still carry the original fee and full set of NFA requirements. The tax stamp elimination is real money back in people's pockets, and the proposed changes around interstate travel and spousal registration genuinely simplify processes that gun owners have complained about for years. But background check requirements, the core mechanism that determines who's legally allowed to buy a firearm in the first place, remain fully in place at the federal level and in a growing number of states. Additional layers of state-level restriction are actually expanding, not shrinking at the very same time. For dealers, the shift away from aggressive enforcement of minor paperwork violations is a genuine reduction in existential business risk, the kind of thing that industry groups had been lobbying for aggressively for years. But it also puts more responsibility on dealers themselves to understand exactly where the line between an immaterial mistake and a serious violation actually sits, since that line is now being drawn by agency discretion rather than a hard uniform enforcement standard applied the same way in every case. For everyone else, the people who don't own a firearm and never plan to, the honest takeaway might be the most important one. This is not a store with a single clean before and after. It's a story about two different levels of government actively pulling policy in opposite directions on one of the most politically charged issues in the country at the same time in the same year, sometimes affecting the exact same category of firearm depending entirely on which government you're asking. That tension isn't a bug in how American federalism works. It's arguably the system working exactly as designed, with different levels of government reflecting genuinely different political majorities and genuinely different views on where the line between individual rights and public safety should sit. Whether you think that patchwork approach is a strength of the system or a genuine problem, probably depends a great deal on where you already stood on this issue before you started reading. And that's worth being honest about too. There's one more layer worth mentioning before we wrap this up, because it explains why stories like this one tend to resurface every few years rather than getting permanently settled. Firearms enforcement priorities at the federal level have swung dramatically between administrations over roughly the past decade. Tightening under one administration, loosening under the next, and then tightening again. Multiple industry analysts covering the April announcement were careful to note that whether these particular reforms actually stick around for the long term depends heavily on whether they get formally coded to orders and published rule text versus a main discretionary policy that a future administration could simply reverse again with a new director and a new set of priorities. In other words, even a package being called the most significant regulatory reform in the agency's history isn't necessarily permanent just because it was announced with fanfare in a room full of supportive industry representatives. Regulatory policy in this area has proven again and again to be a pendulum rather than a fixed point, and there's no strong reason to assume this particular swing is the last one we'll see. So where does that leave us? On one side, you have a federal regulatory agency describing its own actions as historic modernization, cutting costs, reducing paperwork friction, and refocusing enforcement on cases that actually involve public safety rather than clerical mistakes. On the other side, you have gun reform advocates warning that loosened enforcement creates real gaps that bad actors could exploit, and a growing list of individual states actively moving to tighten restrictions on the exact same category of firearms the federal government just made easier and cheaper to own. Both of those things are true at the same time, which is exactly what makes this story worth understanding in detail rather than reducing to a single headline in either direction. What do you think? Does this kind of federal deregulation paired with state-level tightening strike you as the system finding a reasonable balance, or does it strike you as a country genuinely split down the middle on an issue it can't seem to resolve at any single level of government? Whether you think that patchwork approach is a strength of the system or a genuine problem probably depends a great deal where you already stood on this issue. Regulatory policy in this area has proven again and again to be a pendulum rather than a fixed point. And there's no strong reason to assume this particular swing is the last one we'll see.